Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. A strategy that many employers have utilized to reduce their exposure to liability under the employer shared responsibility provisions of the Affordable Care Act, commonly referred to as the employer mandate, may soon be called into question if a group of employees wins a class action lawsuit that they recently filed against their employer. That strategy is reducing the hours of workers in order to reduce the number of ACA-defined full-time employees, and thereby reduce the group of employees that a company has to offer coverage to. As we've discussed in earlier episodes, the ACA requires that a company offer affordable, adequate health insurance coverage to full-time employees, defined under the ACA as employees that work at least 30 or more hours on average per week. If all employees of a company work under 30 hours on average per week, an employer will not be subject to penalties under the employer mandate provisions of the ACA. On May 8, 2015, this class action lawsuit was filed in the Southern District of New York against Dave & Buster's, alleging that Dave & Buster's attempted to use the strategy in order to interfere with the employees' rights under Section 510 of ERISA. Generally, Section 510 of ERISA makes it unlawful for any person to discriminate against a participant or beneficiary for exercising a right granted under or interfering with the attainment of a right under ERISA or an ERISA employee benefit plan. In this case, the plaintiffs are claiming that the employer reduced work hours to below that which the ACA would categorize as full-time in order to avoid penalties under the ACA's employer mandate provisions, and that this interfered with their attainment of a right to benefits under their medical plan. This lawsuit has significant implications for health plan sponsors. Under ERISA, the courts have historically granted employers considerable leeway to change work hours and thereby eligibility terms as business needs may require. A decision in favor of the plaintiffs should cause most employers to rethink this commonly utilized liability reduction strategy. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.